morning, ladies and gentlemen. My name is Athena Bourka. I am from ENISA, the EU Agency for Cybersecurity, and I would like to warmly welcome you to our panel discussion today, which has the title Security Meets Data Protection, Risk Assessment, Standards and Certification. Before I give you a short introduction to our theme and start the discussion, I would like to introduce you to our speakers today, after thanking them again very much for accepting to join us in this interesting topic. So right next to me, we have Thomas Zerdik. Thomas is head of the IT policy unit at EDPS, and before that, he, among other things, he was also member of cabinet for the European Commissioner's first Vice President Timmermans, and he also acted as deputy head of the data protection unit at the European Commission DG Justice. Right next to Thomas, we have Barbara Vieira. Barbara works for ABN AMRO Bank in the Netherlands as a cryptography consultant. She is and she has been also in the past involved in advising companies and software development teams on how to develop with secure code, and she recently also assumed the position of product owner of the crypto team in the bank, and therefore she's very eager to start working on privacy-enhancing technologies within the bank. Then right next to Barbara, we have Jan Salabuk, who is attorney at law and partner at iRights Law, especially in charge of data protection and compliance. In the past, he also worked with the Data Protection Authority of Schleswig-Holstein in Germany, the ULD, and he is also chairman of the ISO PC 317 on consumer protection, privacy by design for consumer goods and services, and he serves as VINE convener for the ISO EEC working group on privacy and identity management. Next to Jan, we have Isabelle Satelier. Isabelle is a legal and policy officer at the European Commission DG Justice Data Protection Unit, and previously she was also a legal officer at the European Data Protection Supervisor. And last but not least, we have Vincent Strubel with us. Vincent is head of the expertise department at ANSSI, the French cybersecurity agency. Vincent's department is in charge of scientific expertise and research, certification, technical guidance, and assistance and training. And as such, it has been heavily involved in the national implementation of the EU Cybersecurity Act. Now, before we start the discussion, as I mentioned, I would like to give you a brief introduction to our theme today. As you know, when it comes to cybersecurity and privacy or data protection, there's always a discussion about balancing, about possible tensions, especially when it comes to cyberspace and internet in general. But however, in this panel, we want to talk about convergence. This is our aim. We start from the main idea, the main concept that security and privacy and data protection are in fact the two sides of the same coin. So security is an enabler for privacy. Privacy is a fundamental protection goal for security. And we also find that this is reflected in GDPR, since we have for the first time security as a data protection principle and a key accountability tool for controllers. So how are all these things, however, implemented in practice? We see that there's still a lot of room for security technologies to embrace, let's say, the very specificities and the nature of personal data protection. And this is what we want to talk about in this panel. How can security and data protection be integrated in practice in the whole spectrum, let's say, so from risk assessment analysis to practical implementation and then also to standards and certification. What is there? What is missing? What can we improve and up to what extent? This is the discussion that we want to have today with our panel. As of the structure of the panel, we will ask first each of our speakers to give us their intervention, their position on this topic, and then we will have the discussion. We hope that you will participate into that and make the whole discussion very interactive. So please share your views, your thoughts, your ideas with our speakers. And then based on this and after this introduction, we will start immediately with our first speaker, who is Thomas, and he will give us the broader perspective of security in the context of data protection from the eyes, from the viewpoint of a supervisory authority. So basically, how can security fit into data protection risk assessment? How does it fit into the principle of accountability?
Well, thank you, Athena, and good morning to everybody. Indeed. I wanted to shed light on the approach on security and the expectations on controllers and processes from the point of view of a data protection supervisory authority. Obviously, data security has always been an integral part of data protection legislation. You all do remember Article 17 of the EU's Data Protection Directive from 1995, which says exactly that. Very good. And now that has, of course, been updated through the GDPR and upgraded to a large extent. As Athena said, data security has been, if you want, elevated, put to the forefront to one of the core data protection principles labeled as integrity and confidentiality in Article 5(1)(f). That's then been even more reinforced in Article 32, which is the main provision in the GDPR on data security, plus, and that is new, of course, the Articles 33 and 34 on personal data breaches, which require notifications to a supervisory authority and communication to data subjects under certain conditions. So you see how the data security provisions are piling up and adding up. And in that aspect, it is, of course, important that data security Article 32 is a self-standing legal obligation for the controller, but more importantly, for any processor. So this is really where processes need to pay attention. But from the point of view of a supervisory authority, Article 32 is just a substantiation of the principle of accountability of Article 24. And the same principle mentioned in, again, Article 5, accountability of the controller. So whatever happens, in our view, in the view of a supervisory authority, the controller has to be able to demonstrate any time of the day, 24/7, that the organization has and is complying with the regulation. And if that demonstration doesn't work, then we've already seen major fines issued by supervisory authorities. Let me just mention, as regards Article 32, violation of data security, the almost 10 million euro fine by the German Federal Commissioner against 1&1, the telecoms company, or the ICO on a London pharmacy for careless storage of patient data. So you have fines directly linked to data security violations. Again, you all know that if we talk about security, many of you will think, okay, it's IT security and that's good enough. And yes, I agree. IT security is there to minimize the impact for the organization of materialized or imminent risk by applying mitigating security controls, and of course planning against that and having measures to prevent all of this. But then again, if you look at the new regulation, the GDPR's requirements on personal data breach handling, that is also an objective to mitigate any adverse effect on the individuals whose personal data security is compromised, but more specifically their rights and freedoms. So that brings me to the first point. Controllers should integrate procedures for dealing with personal data breaches in their procedures for information security incident management. That's the first thing, and I think that speaks already to the convergence of these two things. And in any case, the prevention of security incidents requires a proactive approach. And if you read 32 of the GDPR, it specifically says there must be a proactive process in place to evaluate the risk assessment and the measures to avoid security issues. But the difference to traditional IT security is that this risk assessment requires not just looking at what are the risks for the organization. That process requires you to look at what are the risks for the individuals who might be affected. So indeed, as Athena said, it's in a way, there are two coins, but you need to bring them now together. Not just looking at what's the risk for the organization, but you need to look what is the possible risk for the people who are affected. So our second take is please go and work on an integrated approach in considering data security and personal data protection requirements, because only that will help you to prevent both IT security breaches and personal data breaches. Speaking from experience, to give you an example, obviously to prevent with technological means the unlawful leaking of diagnostic data from office software is both useful from a security point of view, but also useful from a data protection point of view to prevent unlawful transfers. So it actually requires that the IT experts talk to the lawyers and vice versa, ideally with the help of the data protection officer. So having said this, again, the supervisory authority, we would look at this from the accountability perspective. And when we look at the accountability, did the controller do what is required? We look at certain elements. One of them is the data protection risk management, which is required. Data protection impact assessment, has that been done? We would always advocate, in case of doubt, even if you're not required to do one, do it. In case you're wondering how you should assess the risk, well, there are dozens of methodologies out there. We will not require you to use only one. There are models out there. There is guidance available. ISO, NIST, the EDPS has guidance on certain things, Lindan. The colleagues will talk a bit more about this. We will also look at data protection by design, how much data protection by design can be effectively shown, which has been implemented. We will look at the state of the art, how much technology monitoring has been done to prevent security breaches, how many privacy-enhancing technologies have been used, and codes of conduct certification. This will all fit in the big box of tools which we will look at, and the more we see and the more we find from the controller, the happier we are. So, again, the best approach in all of these things from our perspective is to have an integrated approach. Don't look at IT security and data protection separately. Put them together, protect the organization, but also protect the individuals whose data you process. Again, the controller knows best how to do that. There are models out there to learn. There's also guidance. The EDPS has guidance on security measures, on risk assessment, which you can very well look into. The good news is these will all be updated from our side. So happy to discuss with you how you see this approach and hearing from the colleagues also what they might think about this. Thank you very much.
Many thanks, Thomas. So if I could summarize what you said in just one sentence, an integrated approach, bringing all the requirements together, then perhaps something to discuss later in the discussion. Does this mean, is it just about integration or about creating different frameworks or changing the current frameworks, for example, for security risk assessment or security software development? And then with this, I would like to actually give the floor to Barbara, our next speaker, who is going to give us a different perspective, that from the, let's say, practical implementation. So development methodologies, implementation of security measures in practice, how well can or are including data protection requirements.
Thanks, Athena. Um, I think I'm the techie person in the team, and I would like to bring my perspective and experience and what I have seen over the past years when looking into security of software systems, and lately and more recently on privacy. So what you see, especially in large companies, is that privacy or data protection is largely being addressed. So there are governance, there are a lot of governance controls in place, and everybody is trying to work together. So the IT department, the CISO department, the security department, together with the privacy officer. But what we also see is that the controls are in place, but they are not always effective. And I think this is when you talk about IT development and software development in general, people lack knowledge on actually how to implement, how to enforce the policies or the properties, the data protection policies. And this is because this is not embedded in the culture of software development. Also, security is becoming more and more part of software development as a requirement. But privacy only 2 or 3 years ago, when the GDPR became effective, became a concern. And the thing is, for security, we have a long history, and we started implementing secure communications 20 years ago. And if you look at the way the world looks right now, we can still see a lot of communications that are not secure. So we are still working on security, and we are still trying to improve the security of the systems. We are not there yet. And now privacy comes as part of a new requirement. So it has been there for a long time, but it wasn't addressed, and now it's becoming a concern. So when you talk to teams, to development teams, you see that they lack knowledge and also the mindset. And I can give you an example. For instance, they collect data that they don't need, and this is a common practice. Just because the system, if you want to integrate two systems, system A collects data and system B collects that, integrates to that system, so you need to collect that data. And they don't even ask why they need to collect the data. And yeah, we are talking about personal data. So this is part of the culture that needs to change. Also, the people that are developing the products also need to be to have knowledge on how to apply the techniques that are already there to enforce data protection. The other thing I see is that for extremely regulated companies like a bank, standards do help a lot because a bank would never implement something that has not been standardized. So what we don't see a lot is standardized products that enable privacy and data protection by design. And I think this is something that is needed in order to be able to enforce it and to implement it in practice. And you mentioned that Lindun, which is one of the frameworks that enables privacy by design developing a privacy by design product. That technology exists. It has been there already for 5 years, if I'm not mistaken. I know that the Lindun owner is in the audience. But the thing is, people don't really know it. And we can compare it as the one that exists already for security. People don't really use it. So if we don't do it for security, there's less motivation to even do it for privacy. So these techniques exist, the privacy enhancing technologies exist, but they are not off-the-shelf solutions. They are not standardized solutions, and they don't come as a service. So one thing that I also learned from the past is that should not expect from a development team to implement security or crypto by themselves. You have to provide it as a service because they don't have the knowledge. So it has to be a service that is easy to consume. Otherwise, it won't be used and won't be implemented. Or if it is, then it's possibly wrongly implemented. So one of the things that I see that is actually needed is more products on privacy that has an off-the-shelf solution that can be used and solve problems and enforce properties that relate to data protection. And of course, I think one of the things that is still needed, and we still need to work on it, it's security and privacy awareness and knowledge, right? So that's something that it's growing. We see it growing, but if you look at a very small company where they only need to develop a mobile application, we see that the mindset isn't there.
Okay. Many thanks, Barbara. So we have made some progress in security, but with privacy, we're still struggling, if I see the general message. And you mentioned that this is to a great extent because people do not know. I've been wondering during, while you were speaking, is it only because they don't know or because it's not integrated, as Thomas was saying before? It's not part of the thing. It's something that the lawyers will do, data protection. It's not part of the system. And you mentioned standards. So with this, we go directly to our standards man in this panel. So Jan, what do you think? How can standards help convergence of security and privacy? Is it possible?
Well, thanks. First of all, thanks for inviting me. It's always a pleasure to be at CPDP. It's great to be on this panel. Yeah, the convergence of privacy and security standards is something that within the groups that I'm looking at ISO has been approached many, many years ago. There was a workshop actually here in Brussels in 2009 in the Schleswig-Holstein Landesvertretung, where we got together back then at ULD a number of supervisory authorities and standardization experts and discussed how should we approach this field. And we essentially went on in a way where we said we want to be able to approach it from both directions. So we already had a very well-established practice with the information security management systems, 27,000 series. And we said we want to follow up with a number of standards that tie into that. At the same time, ideally also can be used separately. And this is somewhere underlying, if you look now at the 29134 Privacy Impact Assessment Standard in ISO, that's something you see. You can use elements from ISMS, but you can also just go the direct route and use 29134. And at the same time, we now have seen the development of a standard that's called 27701, which attaches to the traditional controls from the ISMS, specific ones from privacy. So to be quick, I could answer the convergence is happening and it's working really well. But of course, it's not always that simple. And I think one could also spoil the party and say, well, maybe there's areas where we don't see that happening, where we won't see that happening. First of all, it's interesting to see if we all know this traditional Venn diagram where we have security on one side and then privacy on the other, and we have these overlap requirements. Essentially what we had some 20 years ago was a situation where privacy was this little thing within security, and security people would essentially do it on the side and get in some privacy requirements. Then privacy came up and we said, well, they're kind of ex aequo. And right now we're in a situation that GDPR is such a strong driver that I always joke that actually GDPR is the security legislation that we have in the European Union. And in a lot of organizations that I work with, the GDPR requirements are the ones that actually drive the organization to implement policies and practices. Now, the interesting question, though, is what are the types of requirements that come in through standardization? And I often compare the situation of standardization we're in with the situation of standards in car safety in the 60s. So we got to be aware of the fact that we're still in the early days, and these processes take tremendously long periods of time, which is a sad side, but that's, at least on the international level, that's something that is to be observed. So there's still a lot of work ahead, and I see a number of new developments coming up where I think it worked really well with the approach that I described earlier with working on the basis of information security management systems. I think there's still a huge area of new standards and activities to be seen. First of all, one of them is a more modern approach that acknowledges that there is trade-offs within security even. I mean, obviously, if you look at the CIA triad, you have a conflict between availability and confidentiality. So models like the standard data protection model try to acknowledge that and take that into account, that you have to sometimes balance things off. But I could also see that there would be a new breed of privacy standards coming into this sphere, which are not specifically and only security-driven, but much more driven by the data protection principles. I'm looking at the transparency principle, for example. We increasingly see standards on the documentation and information practices, but this is still, from my perspective, too early right now, or maybe the standards are too late. We should have started much earlier, and that could help things a lot if we have like an agreed terminology. I see interesting work in W3C, for example, who are doing semantic and taxonomy work there, which might help tremendously. And I would expect that we actually see some approaches that actually go beyond GDPR compliance, because standards can also help ensure trust in the market where actually legislative compliance doesn't sufficiently get there. One example for that could be if a data controller would like to signify that he is not collecting a lot of data, although he would be allowed to. For example, he hosts a website, very simple example. He would be allowed to, at least that's my reading of the law, to collect IP addresses for a certain amount of time, for a short period of time, to look into it in case of security incidents. But it might be that a website website hoster just wants to say, we're not doing that, and you can be safe, and he wants to signify that. And we've seen these things in Germany some 15 years ago when we had the data retention discussion. But another example of such standards could be standards that actually address the producers of products, or that address products that don't even have a data controller, which is one of the limitations of the GDPR, to be honest. We're just looking at it at the perspective of data controller and data processors, but there's a lot of consumer devices in the houses where it's not entirely clear where the data controller is. Nevertheless, there is a lot of sensitive data on these devices, and if they are stolen, that sensitive data might leak out. In concluding, I think the development is doing really well. We do see some convergence. There's one shortcoming that I currently see, but that may also be due to the perspective of looking at this from the ISO International Standards Organization perspective, is that a lot of the standards we're developing are not very much geared towards smaller enterprises. And we're on a kind of, we see that we're in a situation where it's increasingly difficult for smaller, more innovative enterprises to actually hit the market, because the threshold, the barrier to entry is so high. If they want to just buy all those standards, they'll spend a lot of money. And that may be a showstopper. And I'm really looking forward to hearing ideas on how to resolve that, actually. Thank you.
Thank you, Jan. So actually, GDPR is a driving force for security, the way you presented it, as a security legislation. But at the same time, security and standards should also look a little bit out of the box, if I understand you correctly, and not be just limited to what to mere GDPR compliance per se. And you mentioned two examples, which I'm thinking that going to the next, let's say, topic that will be brought on the table, that labeling certification could definitely be a way to go forward. So I will pass now the floor to Isabel, who will give us the perspective of the data protection certification and how security fits into that.
Yes, thank you. Good morning, everyone. I wanted to give us a bit of a perspective of the landscape that we have in Europe on certification, and also where we are now, where we are with GDPR, and also looking also a little bit broader, as you say, as other mechanisms that also exist, and what we can do to find some convergence also between that. So as you are aware, in the certification landscape in Europe, we have a very specific mechanism for certification under GDPR. It's a bit different from the rest of the certification that we issue in Europe in a lot of other fields to certify compliance with other types of regulation. Here, we have some specificities. First of all, when we talk about certification under the GDPR, we talk about certifying processing operations. We recognize that these processing operations may be part of a product or a service, but as such, a GDPR certification will not lead to a company, a product, or a service as such to be certified, but the underlying processing operation. And it makes quite a difference with respect to other certification mechanisms. I will talk a bit later on the cybersecurity certification schemes, and they have as their scope more generally the certification of ICT products, services, and processes. When we talk also about certification under GDPR, of course, we have to certify compliance with elements of the GDPR. It can be quite a comprehensive scheme. So we could have a horizontal scheme to certify compliance of, for example, processing operations in the health sector or specific processing operations for the cloud. But we could also decide to have specific certification only for one element of compliance, and that could be security. So we could also develop mechanisms for just certifying the security of the processing operations. And actually, even in the GDPR, in Article 32, it's very emphasized that certification has really added value in the area of security in order to demonstrate this compliance with those obligations. When we look at existing standards and existing certification, the Commission did a study, we did a study in 2018 to try to have a bit of a panorama of what were the current certification mechanism and standards that were developed already under the Directive 95/46, and that were also looking at security and privacy aspects. And there were already a lot that had developed in the market. However, what we found is that they all needed adaptation to the GDPR. Of course, the GDPR brings a lot of new legal requirements, but also new elements of procedure in the way that these certification mechanisms can be approved and put forward on the market. And so at the core of that, I would say they are the task of the data protection authorities, because they have a very central role. They have to define what are these additional requirements under which the certification body and the accreditation body and the certification body will operate the certification. And they also have to agree on the content of certification. They have to be satisfied that a particular certification mechanism brings a sufficient added value to ensure this compliance with the GDPR. So there have been quite a lot of steps, I would say, to take before certification mechanisms can be on the market under GDPR. I want also to say that we see evolution. This is underway. For instance, at the European Data Protection Board level, they had to agree first on a common approach to certification and to accreditation before national authorities could start approving those certification mechanisms. Now we have the guidelines, so things are now in the process, so we can start seeing also on the market schemes that can help companies demonstrate compliance that with the GDPR be put in place. So it's a matter of time, but we are seeing quite a lot of progress in that area. Another point that I wanted to bring is that, of course, we have talked a lot about the security and privacy elements that are required for compliance with the GDPR. At the same time, when we look a little bit broader, we see that last year we have this new Cybersecurity Act that was adopted. And of course, there are differences in the schemes. The scope is not exactly the same. The procedure for approval of the two certification mechanisms are not exactly the same. But we are also reflecting to what extent these cybersecurity certification mechanisms can also have some synergies with the certification mechanisms under the GDPR, in particular when it comes to certifying the security of processing operations. Of course, under the cybersecurity, not only personal data is addressed, it's a much broader approach to the protection of network and information systems. So it might concern also non-personal data. But I would say that when you look at the core aspects of what the security aspects that must be protected under the GDPR and the Cybersecurity Act, I think that we can see that they share quite a lot of common goals. And it would be interesting for us to see quite some interoperability between the two certification mechanisms and to see how, for example, certification mechanisms that have been developed under the cybersecurity scheme, to what extent they would also be compatible with the ones for security under the GDPR, or how they could fit some part of the security compliance under GDPR, and if there are elements that need to be added, what would those elements be? So I think we are currently putting a lot of attention to that, to try to create more of these synergies between these different elements of certification that can help each other, and also certainly help companies when they have to comply with one particular certification scheme, that they could also benefit from a recognition of that scheme in another area. So I would stop here.
Thank you, Isabel. So security is an element of data protection certification. Of course, cybersecurity certification is something different. Then maybe this is an area where we can find an actionable way to create a synergy, exactly because it's also something very specific and actionable certification. So, Vincent, I will now give the floor to you to drive us through the same ideas, but from the perspective of the Cybersecurity Agency.
Well, thank you, and this is a very interesting topic, and I believe a crucial one. First of all, I'd like to say that from our perspective, cybersecurity and data protection have always been two sides of the same coin, with different roles, but fundamentally the same set of technical requirements. That's why we've been working for years with CNIL, the French supervisory authority, bearing in mind that we have a significant difference in role and status, because ANSSI is part of the executive branch of government, we're attached to the Prime Minister, and CNIL is an independent authority. And that, by the way, it's great that it is this way, it's needed, but that might complicate a fully integrated approach, at least from a regulator's point of view. But within those bounds and those limits, we've found quite a lot of common ground with CNIL. This is reflected, for example, in the cross-referencing of a lot of our standards and documentation. Before this talk, I checked the main how-to on data protection on CNIL's website and found 15 references to pages and documents on ANSI's website. And conversely, we point to a lot of CNIL documents in our own recommendations. And we've been integrating, by the way, personal data protection requirements in our own approaches and documents. To give you just one example, we have a risk assessment methodology which we call EBIOS Risk Manager, and the latest version has a new focus on personal data because it's, as it was mentioned, it's the main driver right now, even for security, because you know. That is not to say that it's always fully aligned between cybersecurity and data protection requirements, and there are certainly areas of differences and possible conflict. And I'll mention two of those that come to my mind. The first is that from a cybersecurity perspective, we need to do a lot of monitoring and more monitoring and inspection of data flows and system events. And that is obviously not neutral in terms of data protection. It usually involves inspecting some kind of personal data. Sometimes it's the personal data of the attacker, but that is protected as well. So we have to deal with it. It's workable. Every time we've had to deal with it, and we worked with CNIL on that, we found ways to address both constraints, but it's not simple. The other emerging challenge, I think, is related to incident response and the reporting and notification of incidents and breaches. We all know that GDPR, in case of a security breach that might affect personal data, encourages swift notification to the potential victims. From our point of view as cybersecurity, when we're confronted with an attacker which is, let's say, an advanced persistent threat that has been in control of a large part of an organization's IT for many years, the first thing we want to do is to take some time to quietly analyze what the attacker has done. For two reasons. Because we want to know how did they come into the system, so that once we evict them, they won't come back the next day. And we want to gather as much information on the attacker to be able to detect them somewhere else. Obviously, public notification of a breach will make the attacker erase all tracks and go away, at least for a while, and that prevents the analysis we need to do. So we need to articulate those two requirements, swift notification and some time for the analysis. And again, this has been workable on a case-by-case basis every time we've had to deal with it, but it's something that warrants more discussion, I guess. Now I want to focus on certification, which is an area that has seen a lot of cooperation already between the two words, but which holds, I think, a lot of potential for further pooling of resources. Cybersecurity certification has been goes back about 20 years in France, just like in many European member states. It was centered originally on specific types of products, smart cards and so on. It's been extended to cover pretty much any security product, any type of security product, and various service providers. It has had interactions with data protection for a while, and I think for years CNIL has been recommending products certified by ANSI for data protection because, for example, an encryption software that has been certified by ANSI meets personal data requirements. A more recent and I think more telling example is that of the cloud service provider certification we've established in France, which we call Secnum Cloud. The requirements for that certification were designed before GDPR, but once GDPR was out, for obvious reasons, it was interesting to integrate as much as possible the requirements from GDPR into our own certification. So we worked with CNIL on that. It turned out to be surprisingly easy to do because in the end, out of about 60 pages of technical requirements, we had to insert or modify about 20 sentences to address specific requirements from the GDPR, such as specific identification of personal data, specific procedures in case of breaches, specific transparency requirements on the use of personal data, but that's about it. In the end, the result is that just by, you cannot ensure compliance with the GDPR just by resorting to a certified cloud provider. But, and the client building an application on top of such a cloud still has a lot to do on their side to ensure compliance. But all the requirements that in the end fall on the cloud provider are met and guaranteed to be met, and the client does not need to worry about them or check them if they could even check them in the case of a cloud provider. And that to me is the good example of how cybersecurity certification can help data protection in the future, not by proving compliance or demonstrating compliance with the GDPR, and it is not redundant or conflicting with the GDPR certification that is centered on the process and skills, but by establishing the prerequisites for such compliance on certain specific solutions. And I guess this makes a lot of sense for all sides, because for us cybersecurity regulators, obviously it makes the certification schemes more attractive to end users and vendors who care deeply about the GDPR for obvious reasons. It also enables data protection regulators to benefit from a well-established process that has years of accumulated experience, strong assurance on competence, transparency, methodology, and so on. And that's even more true with the European Cybersecurity Act and the European certification framework it establishes, because it enables us to scale up national certification scheme at the European level where they make more sense. It also enables us, and it's the opportunity to address some shortcomings of the certification process that we know, especially in terms of dealing with the whole life cycle of the solution and vulnerability and patches and updates, which is not addressed quite as good as well as it should be right now. France is very willing to invest resources and experience in populating that new framework, and I believe the proper integration of data protection requirements in the new framework is a key factor to success. Finally, I'd like also to point out that the certification schemes envisioned by the Cybersecurity Act are a tool, a flexible and versatile tool in the hand of any regulator dealing with IT, and so they're not owned by the cybersecurity regulators, and they could very well be used directly by the data protection supervisors to address specific use cases from data protection concerns, such as anonymization that does not make a lot of sense from the cybersecurity side of things, but is very useful in data protection. So they could very well design their own schemes under the Cybersecurity Act or use existing schemes to address those use cases. So to sum it up, I very much believe we need to continue developing coordination and cooperation or integration as much as possible between those two words, because there's more than enough work for both sides.
Thank you, Vincent, for bringing up good best practices and lessons learned in this area. I think you focused especially on how the integrated approach that we heard also before by other speakers. So how we can embed data protection requirements into security schemes. And then there's also the question how data protection schemes can benefit from the integration of security requirements. So there's certainly a lot of work to still do there, but what you told us is very positive. Thank you all very much. I would first like to ask the audience, all of you, if you have some questions to our speakers. Thank you. Please say your name and...
Hello, I'm Tobias Moschus from Datenschutzraum Germany. Mm-hmm. And my question is, you talked a lot about bringing those worlds together and the requirement for data protection to have security. My question is, how is it the other way around, having data protection as or privacy as a requirement for security? Because lots of attacks we see today are based upon data breaches or social engineering, so there's a lot of private data involved to breach the security. So how is it the other way around?
Who would like to start?
I think the traditional dichotomy, to use that word, between security and privacy, where security treats the organizational risks and privacy treats the individual risks, is more and more vanishing. And that is also due to the fact that we have the GDPR, because now the privacy risks of an organization become an organizational risk due to fines, due to the reputation loss, etc. So it's really not that way anymore. It's really tied together in a way. So essentially, privacy may even further than help reduce traditional security risks. But it's not separatable anymore, I'd argue, in a lot of cases.
Anyone else?
Just to confirm, as has been said, that nowadays privacy and at least in the European Union, GDPR compliance is very much the driver for security in a way. And to confirm as well that the availability of private data is very useful for attackers, and nowadays we deal with well-organized attackers in terms of cybersecurity that know a lot and they do their homework on preparing an attack and then getting knowledge on people, administrators, for example, and targeting their attack. So what we see quite often is that the attacker knows the IT system they're attacking much better than the legitimate operator, which is a problem in and by itself. So yeah, very much, and this leads me to the conclusion that transparency is not in a position with cybersecurity, and some organizations are still in a position where they don't want to. They're afraid of transparency because that might expose them to more attacks. It's not the case because the attacker know everything they need to know nowadays, and more transparency won't hurt security.
Barbara, yes.
Can I also say something? I think it's a bit more productive. So I do agree with you, guys, but what I also see is that having data protection or has a requirement for security doesn't work, because you can collect as much data as you want, as long as you keep it secure, and that's basically the mindset, and it shouldn't be, right? So it should be the other way around. So you don't collect, so you don't breach it. But the thing is, there's still this mindset, unfortunately, that even if I collect whatever I want, if I keep it secure, then I'm fine. And this is something that needs to change, and is changing. So.
Anyone else would like to reflect? Okay, so next question, please. Thank you.
My name is Alexis Duclos from the US, and my question is about the certification and some of the sort of what might come out on the market. We've seen some things are self-certifications that exist already. Some things are certifications offered after analysis by a third party. And I'm just curious for people on the panel, what you see the trajectory of what might come out in terms of GDPR certification, whether that might be more self-certification or third party, and what might be the most sort of viable route to take.
Would like to start?
Well, I think that under the GDPR, if you look at the guidelines from the EDPB, we have a system where we have this accreditation of certification bodies, and the certification is done by certification bodies. So we would rather go for a system of third-party certification than a system of self-certification. But we know this exists in other areas and can also be valid. But I think under the GDPR, we need to have this assurance from a third party.
Yeah, if I can jump in on this, from the point of view of a supervisory authority, again, as I've explained, accountability. So whatever rocks your boat. And if you're relying on the third-party trusted GDPR certification, which the GDPR requires, that'll be a great element which we can then study and look and assess how much accountability has been done. If the controller relies on something else, maybe as well, if it's a self-certified thing, as long as it's well documented, as long as the risk assessment is properly done, as long as we have something to work on, that may also be fine. So, as I said, we'll have to see what the market will offer, but in the end, what it boils down to is when we as a supervisory authority come out there and talk to the controller, what the controller then can put on the table. Then we'll take it from there.
Just maybe to add on to that and share the perspective and the feedback from the cybersecurity scene. There's probably room for every type of approach, even self-certification, but the added value is in third-party certification, and that's been the focus of the cybersecurity certification so far, with a strong emphasis on vulnerability assessment by competent evaluators, and the role of my agency in this scheme is to ensure the evaluation facilities have the right kinds of skills and tools to do the right job, and are in a way as skilled, hopefully, as the would-be attacker, and will find the vulnerabilities before the attacker finds them. So for the vendors themselves, the added value is in having a third party that is more skilled than them, probably in evaluating vulnerabilities, do the vulnerability assessment. Because filling a self-assessment is useful, but does not improve your product much, whereas having a third-party audit your code is a lot of help.
Okay, next question, please.
Yeah. Hello, I'm Stefan Schiffner from the University of Luxembourg. I want to stay on topic on certification and also on the parties which are involved. So the GDPR, in my reading from 42 and 43, Article 42 and 3, it gives you actually two kind of possibilities who is responsible for a certification scheme. This could be the Data Protection Authority, or this could be a more independent party. My problem is, or my question here is a bit, has anyone an idea why the Data Protection Authority should be there in the driver's seat in developing certification schemes? To me, this looks pretty much like a conflict of interest, because in one place you make a scheme, then you certify a company, something goes wrong, and then the same one who has certified, or at least was very much under control to certify, has to fine this party because something got wrong and something got leaked and it was a big disaster. And certification does not avoid disaster, so we need to plan for the disaster. So how do you resolve this conflict of having the certification scheme development in the driver's seat, the DPA, and then also, of course, in the fining process, if shit hits the fan, as they sometimes say.
I think Thomas.
Very briefly, I don't see the conflict, actually, because obviously we know from controllers and processes, everybody wants guidance from supervisory authorities. And I think that type of certification is the best guidance you could ever get, because you get it from the people who indeed do the supervising. So it's fortified, it's guidance plus, it's approved, trusted, and as I said before, that's something you can then actually show. And obviously, it will not prevent you from having problems, but the fact that you have this in place, that shows already to the supervisory authority, hey, that's somebody you can do business with. They have taken their obligations seriously, and that will then be a factor, obviously, in the assessment from the supervisory authority in the fine or in the reaction on the incident. So I think it's not a contradiction at all. It's actually a much more improved, fortified guidance to help controllers and processes.
Anyone else on this?
I think I have to object. I find that argument quite convincing, actually, that there might be a conflict of interest in those cases. However, it really depends, and that says somebody who was affiliated with the DPA, who did certifications themselves. back in the days. And it never arose as a conflict back then. But I can see that case actually happening. Now, if you read Article 42, though, or at least my reading is that the supervisory authority is in the role of accepting the accreditation. So they're usually not developing the scheme themselves. At least that's not what I expect to happen in the market. But yeah,
I know at least one which is in a driver's seat developing a scheme.
Okay.
This is
okay. Interesting.
Vincent, you wanted to add something?
Yeah, I think I'll leave it at there. I think I just wanted to have the panelists balanced here in this.
Did you want to add something? No, or maybe. Okay. No, I thought you wanted to add.
Or I can just.
I don't want to force you to add.
No,
I just
put me on the spot. But from the cybersecurity side of things, we've avoided for some time having to deal with sanctions because we identified that might be a problem. So we're not into giving sanctions at ANSI. But that role is being given to us more and more through several regulations, so we have to deal with it. I think it's interesting to read what the Cybersecurity Act says on this, because it distinguishes two roles. The certification accreditation body, which accreditates the evaluator facility and ensures the scheme is working properly, and a national cyber certification authority which monitors everything and sanctions possibly. The two roles can fall on the same organization, and in France, ANSI will be the NCCA and the CAB, the accreditation body. But we will need, due to what is specified by the Cybersecurity Act, and it's a good thing, we will have to organize things in a way that such conflict of interest is impossible, or at least detectable.
Okay, we'll move to the next question then.
Hi, this is Alex Lee from Microsoft. Just one comment about conflict of interest. Please reference FAA certification of Boeing 737 MAX. And I think they will feel quite regretful about where they're at right now. So questions for you is about international cooperations, right? So you have GDPR certification. If you look around the world, you have APAC CBPR, you have Singapore has a trust mark for privacy, New Zealand has one, Japan has one, so on and so forth. It goes on and on and on and on, and there'll be more. So if we go on a kind of insular, inward-looking approach to keep thinking about just GDPR certification, I think we're likely going to see a landscape in which only a small number of very, very well-resourced companies like Microsoft be able to operate everywhere. So I would ask the panels to kind of comment on the international cooperation aspect of certification, in which you do not create an environment to which you create a monopoly for a company like Amazon and Microsoft. We like to compete other ways, but not through this way.
Who would like to take this?
I could weigh in to some extent. Within ISO, within the groups that I have the pleasure to work with, I usually emphasize that we're trying to expose requirements that meet legislative requirements from all jurisdictions. So often when somebody shows up that is new to international standardization, they will say, no, we don't need this as a requirement because it's not required in our law. And then I'll go and say, you know what, it's required by their law, and you want to comply to the standard to be compliant with all legislation. Usually that works. There may be some cases where there's actually conflicting laws, but in most cases, if you kind of take the best of all worlds together, that should then be in the ISO standard. And sometimes that's frustrating for a number of participants and experts, because they say, well, this is going to be a tough call on our enterprise to fulfill this specific requirement from that specific legislation. But ultimately, that's how it works. You comply with one international standard and satisfy legal requirements around the world. That would be in an ideal world, but that's the only way I could see that happen, actually.
Okay, next question, please.
Yeah, hi, I'm Ronald Lane, Tilburg University. We hear the EDPS representative mentioning that certification is primarily, in his view at least that's what I understand from him, that its primary purpose is to show compliance or demonstrate something to the regulatory authorities. But the primary function of certification seems to be much more a signal in the market to consumers that you can trust this organization because they have this certificate. And so we have all sorts of seals and marks and things aligning with these certification schemes, right? Now, and then there are two issues that are really important here. One is that you also mentioned that it's okay if we have a self-certification, so not third party, but self-certification because it shows something about compliance. But actually that's very dangerous because then we get this sprouting of signs and marks all over the place where nobody understands what these things actually mean. And they're typically colored with check marks and golds and what have you. We see that a lot in food products, for instance, where the most horrible stuff actually has a label that says this is healthy stuff. No, it's not. So that's one concern that I have with the certification schemes that we currently have. The second thing, there is indeed a much larger issue with checks and balances within the data protection authorities playing in the certification domain, because they have to approve the requirements that are present in a certification scheme. The DPAs could do the certification themselves, and they also could play a role in the accreditation of the certifier. So they play on different levels, and the market doesn't understand that. So in that sense, I think but that's my personal thing. We worked for the Commission, but my personal thing is that this was a missed opportunity for the legislator to get certification right in the GDPR. So now to end up with a question to all panelists, do you see possibilities here to fix all of this under the GDPR or a follow-up, that we have clearer models for certification in this domain, while we at the same time try to integrate data protection certification and a cybersecurity certification? I mean, there's an interesting field here.
Very interesting, a lot of things in this question. Who would like to attempt an answer? Yeah, Isabel.
I have to start to say that let's be clear that right now the GDPR is not open for revision. I think we have just 2 years of entry into application, and everybody is still digesting, trying to comply with the rules. So I think from the side of the Commission, at the moment, the best we would be able to do would be to try to see with the means that we have the possibility of a delegated act and an implementing act to come and remedy certain deficiencies in the market if we observe that. I must say that we still need to see in practice how those schemes under GDPR are operating. As I said, we see a lot of progress. We know it's going to come. And we have those tools then at the Commission level to try to make it work better if that doesn't work. That would be my answer.
Thomas?
Yeah, just on that, I agree, of course. It's certification, first of all, it's not a legal requirement. It's a tool. And therefore, it's up for the controller to decide should one do that or not. And yes, I agree, it's a possibility in the market to show compliance, and that's great. And wouldn't we all wish that there was this one certification and I run it through and then everything is fine and there's only one, and if I have that certification, supervisors, authorities will tick off and say fantastic. But life and reality is more complex, as we know. We've seen now only the convergence of security, certification and privacy coming together. So even though that's been in the market for some time. So I think we see, and this is the GDPR has I would think, a welcome tool proposed for the market. We'll see how it works. I am encouraged to see that there are movements in the market, but ultimately for a supervisory authority, we'll have to assess case by case in case there is an issue. And then, of course, it'll depend what is the trustworthiness of that certification. And indeed, maybe a GDPR certified 42 procedure certificate is more reliable than any self-certified tick box, obviously. But that is something we as supervisory authorities will have to take into account and will take into account. But again, the development hasn't finalized yet. It's just started, so I wouldn't be so pessimistic on that yet.
Anyone else also?
Maybe against, again, from the cybersecurity side, a few comments. In cybersecurity, certification has been up to now pretty exclusively voluntary. I know only of one specific case in French regulation where you have to be certified to operate in a specific market. But beyond that, it's been a way for vendors to distinguish themselves on the market. And as such, it's been very important to make it difficult to get certified, to focus on third-party evaluation and make sure it's difficult enough. Just to give you an example for the product certification we have in France, we have about a 50% failure rate for first certifications. If you're a new vendor and you want to certify your solution for the first time, you have one chance in two of failing and not being certified in the end because we found a vulnerability. So that's good news for us, not for the vendors possibly. But it makes sure that is a real valued distinguisher on the market. Nowadays, we're moving more and more towards mandatory certification in many fields, and that's the end goal, I think, of the Cybersecurity Act, is to make it available for regulators as a tool, and so make it mandatory. In that case, self-certification might make sense for some cases, because you can put it into regulation that you need to be self-certified to operate on a specific market, and if you lied in your self-certification, you go to jail or something, and that makes it possible to control this. But as a market distinguisher, again, I think the only way this works is if it's difficult enough and based on third-party evaluation.
Okay, it looks like we are approaching the end. So before we close, I would just like very quickly to ask you to reflect, like in 30 seconds, if you can, on what is the most urgent area where you see that we should work in the next years before we meet again and talk about this, on putting together data protection and security requirements. Thomas?
Yeah. I think having the conversation between supervisory authorities on the one hand side and other agencies in the security field, that makes more sense to just have the awareness how much convergence there could be. That's certainly something we will try to look at, to have this cross-references readily available.
Barbara?
I would say standards of products and certifications, but not the ones where you just tick the box, because we have a lot of those and they are not that effective.
I learned a lot with the last round of questions on the certification, and I see that that's a point that where other people are also uncomfortable sometimes. We're approaching the 2-year evaluation phase of the GDPR, so it actually is scheduled to look into this. Not suggesting that we're opening this up, but I think the area of Article 42, but also of Article 40 actually, still have quite some potential that needs to be used.
Yes, I confirm we will do an evaluation in May. We will see how far we can go into all aspects of the GDPR. From my side, I would just concur with Thomas that I think that what we need to do is to encourage this dialogue between all the relevant regulators, the data protection authorities, ENISA also on its side, the certification authorities under the Cybersecurity Act. I think we need more of this dialogue to make sure that we are all in a converging mode. Yeah.
Well, you mentioned one topic. I have two, if I may. First is working together, because it makes sense both for cybersecurity and data protection, on the common building blocks that everyone uses, and which often are open source software, and making sure those are secure and reliable. Because one example, everyone doing crypto, except possibly Microsoft, uses OpenSSL, and we realized collectively recently that it was not as secure as we thought, and we need to invest collectively again on the security of those. The second topic, I think, would be, from my point of view, would be artificial intelligence, or what we call artificial intelligence nowadays, which is mostly machine learning, because frankly, I have no idea as to how I would certify a machine learning-based solution if someone asked me to do so. And I guess the question is the same from the data protection side of things. And the issue is the same as the transparency, the absence of a specification. How do we prove something is behaving as expected if we don't know, we don't have any expectation as to how it should behave? And that's a topic that is very interesting, even from a scientific point of view.
Okay, thank you very much all for the discussion, and all of you for attending and participating. And thanks.